Good morning, everyone, and welcome to another webinar in our 7-part series, Communicating Product Safety. We are so glad that you've joined us again today, and we are grateful to the Society of Product Safety Professionals and ADK Information Services, who have worked hard to put together this wonderful series about communication and product safety and why it's such an important skill for all of us within the community. And we've been looking at ways that we can best alter our communication skills, techniques, and tools that we use across various stakeholder groups. And today is a very special session with two faces I know you all recognize on communicating with regulators and within a regulatory setting. So certainly that's something that we all are faced with on a regular basis. And I am very much looking forward to hearing from our speakers today. And just a couple of housekeeping items before we get started there. We are recording these sessions and they will be available after the series has concluded on the CPSC website. So you can certainly go back and check out any content you may have missed or revisit some favorite topics. We are also keeping participants on mute, but certainly encourage any questions or comments that you may want to interject throughout the session or ask of our speakers. You may certainly do so, and you can do that by using the Q&A function at the bottom of your screen. You'll see an icon there, and certainly any anecdotes you'd like to share with your fellow participants, drop those in the chat. We've been having a lot of fun over the past few sessions that way. And so without further ado, I would like to introduce our two speakers today. We'll be hearing from Eric Rubel, who is the former CPSC General Counsel and partner at Arnold Porter. And Eric is joined by his colleague, Michelle Gillice, and she is also former CPSC compliance attorney and is also currently with Arnold Porter. So without further ado, drop your questions as you think of them, and I will turn it over to Eric and Michelle. Thank you both again.
Thanks, Lisa, and we really appreciate the opportunity to talk to you today for the next hour. Please do ask any questions that you have. We'd be happy to address them either during the session or at the end. Wanted to just let you know what we'll be talking about today and go over the agenda really quickly. We're going to be talking about the keys to effective communications with regulators, focusing on CPSC. We're going to identify challenges in effective communication with CPSC. We're going to make sure everyone has a same framework, an overview of the Section 15 reporting requirements, the consequences of non-compliance. We're going to talk about briefly a communication scenario to make the point, some of the points that we're trying to communicate today. And we're going to address how to overcome, what are some of the keys to overcoming the challenges of effective communication with CPSC. So the foundation, in our view, for effective communication with CPSC is a combination of having the right corporate culture, communicating effectively internally and with business partners, and processes that will permit you to know the facts and act on them. Effective communication with CPSC can either be facilitated or undermined by these three factors. The Department of Justice has made clear that it draws a link between company culture and processes in DOJ is evaluating whether a compliance program is adequate in criminal cases. And what DOJ has said is just one snippet, quote, beyond compliance structures, policies, and procedures, it is important for a company to create and foster a culture of ethics and compliance with the law at all levels of the company. The effectiveness of compliance programs require a high level of commitment by company leadership to implement a culture of compliance from the middle and the top, close quote. And that really captures it pretty well about the importance of how success starts at the top and from the middle within a company. Process is only as effective as the people implementing it. So training is going to be critically important, as is helping ensure that you've got the right people filling the right roles to implement the processes that you have in place. When we think about communicating effectively with CPSC, credibility is really at the top. And this requires, to have credibility with CPSC, you've got to prepare, and you're preparing it before any communication with CPSC and each communication with CPSC. You've got to know the facts based on the available information. And keep in mind, critically important, that facts are not aspirational. What we mean by that is the facts are the facts. It's not what you wish the facts would be. It's not what would be convenient for the facts to be. It would not be what's most beneficial for the facts to be. The facts are the facts. You've got to be careful not to state or imply that a limited set of information is everything, even though the facts may be evolving, your understanding may be evolving. So we always talk about the information that has been identified to date. We don't talk about the number of reports that have been received to date, because that could be evolving in terms of your knowledge of that. We urge our clients to stick with the facts and not to overstate what is known or speculate. You can always follow up with another submission. You can always be more definitive in your conclusion when that's justified based on your understanding of the facts. And then there's credibility through follow through. If you tell the staff you're going to do something like checking for additional incidents or performing additional testing or evaluation, do it and report back to the staff as appropriate. You should be checking for and acting on changed facts over time, including before any communication with CPSC. And you should consider whether your initial review and analysis of information was sufficient and reanalyze it if it's warranted. For example, should you be using additional search terms than those that you use to identify the incidents? Is it possible that additional models are affected that share the same design or feature as the product you've notified CPSC about? Has additional data been received since the initial analysis? This requires you be willing to ask the tough questions all the time. Someone has to be willing to raise their hand and say, you know, I know we thought it was X, but maybe the affected products are greater than we originally thought. And this, you know, may not make you the most popular person at the table at the time, but it can be critically important to your credibility and getting it right. Michelle?
Thanks, Eric. So we know when you're communicating in a regulatory setting and trying to do so credibly, you're not doing so in a vacuum. And there are a number of challenges that you face in doing so. First and foremost are time challenges. With communicating with CPSC in a Section 15 scenario, there is time pressure to notify CPSC immediately. And that can be difficult to do when you're digging in and trying to understand the facts as they're evolving. You may have varying degrees of supply control and commitment from your supply chain. Regulatory regulations and industry consensus standards aren't static, they're evolving, and your product isn't static. There may be changes over time that affect compliance. And as Eric was just mentioning, there can be a disinclination to revisit prior decisions. And certainly that can occur when there's been a flag that someone's noted about a product, maybe a potential product safety issue, and there's a decision that, you know what, we think this is really a quality issue. And then relying on that initial decision as the facts might evolve and change, there can be a real reluctance to go back and check and see, should we still rely on that prior decision we made about the product? And there's also a desire for certainty. I mean, when there's a potential issue or a potential problem, there's a desire to bucket the information and say, this is what it is. And that can be done at the cost of accuracy. And so there's a real need to temper your desire for certainty in explaining the issue, whether internally in the business, and then with CPSC, placing a premium over certainty over accuracy can lead to problems.
Michelle, I just want to jump in real quickly on this one point that you made here. I think is really important, and that is the disinclination to revisit prior decisions. This is a real phenomenon that we see repeatedly in counseling clients, where a company makes a decision, folks involved with all the best intentions, make a decision that something is not reportable based on the information that they then know. It can be a real challenge for folks to then say, wait a second, the facts have changed. We've identified additional incidents. We have more information than we used to have. And we really need to go back and think, okay, I know it may have been the right thing to do at the time that something wasn't reported, but is it really right now? Or is the scope really different? It takes a real commitment to go back and acknowledge that you may not have had it right the first time around.
Thanks, Eric. Other challenges that you'll face is that CPSC is not the only regulatory body you're dealing with. There are other federal agencies that may regulate your product. Certainly, there can be state law requirements that are even more stringent than federal requirements. And if you're selling a product outside the US, there are other jurisdictions with requirements on reporting and safety issues that you need to be aware of. And certainly product safety issues can impact certifying bodies and whether you need to notify UL about a potential product safety issue. So CPSC, we recognize, is not the only consideration. Compliance with CPSC regulations is not the only consideration on your mind. So we're going to set up a communication scenario just to talk about credibility in communications with CPSC and in a section 15 scenario. And so in order to do that, we're going to briefly touch on section 15. We know that you're familiar with it, and so this won't be section 15 101, but just so that we can level set. We all know that the duty to report under section 15 arises immediately upon obtaining information which reasonably supports the conclusion that a product either fails to meet a mandatory standard, contains a defect, which could create a substantial product hazard, or creates an unreasonable risk of serious injury or death. So section 15 we're focusing on because this is one of the key areas that you'll be communicating potentially with CPSC staff. And immediately is a challenge, because we understand that trying to get your arms around an issue and reporting it immediately it is quite a challenge. CPSC allows for 10 days to investigate, but for those of you that have been in a reporting situation, you realize how quickly 10 days passes in trying to get your arms around the information. Now, CPSC's position, just so that we're all clear on it, staff believes there's a duty to notify even absent the need for a recall, even absent a product defect, incidents or injuries, a root cause determination, scope determination, or any violation of a regulatory standard. And that's important because companies can often, in trying to do the right thing, try to identify the root cause, but that can take a lot of time. And CPSC will look at an issue and look at early flags, and waiting to get to the root cause may impact the timeliness of your report. Now, we talk about reporting to CPSC because when you do so, and the duty to notify is immediate, what you say is a representation of your company. You're establishing a relationship with the compliance officer. You're creating an impression about the company's culture and whether the company is trustworthy and reliable. And just to briefly touch on the potential consequences of non-compliance, the civil penalties for failure to timely report to CPSC have just gone up effective January 1, $120,000 per violation, and up to $17 million for a related series of violations. And violations not only include late reporting, but also material misrepresentations to CPSC. It's a knowing or should have known standard for civil penalties, but criminal penalties for willful violations are possible. And we know that's possible now because of a recent resolution of criminal charges this fall with DOJ for late reporting, the first of its kind for a corporation. Non-compliance with CPSC, putting penalties aside, can cause, and this is really important, it can cause the company to have a loss of credibility with CPSC staff in ongoing and future matters. CPSC staff tends to stay and work at the agency for a long time. They have a long memory, and rebuilding credibility with CPSC after you've lost it takes time. And it's not the position you want to be in with staff. And aside from CPSC, there are risks of non-compliance can affect your product liability exposure and overall, present harm to your brand reputation.
If you've got want more information about the Section 15 reporting requirement, our team publishes a desk reference that addresses in great detail the Section 15 reporting requirement. It's available online. You can just Google Section 15 desk reference, it'll come up. We're going to be updating it again within the next couple of weeks. And it is an exhaustive, if not exhausting, walk through the Section 15 reporting requirement. So I encourage you to take a look at that.
It's a good read, Eric. Come on, it's not exhausting.
with a couple of good cups of coffee.
All right, so we put together a communication scenario just to illustrate communicating credibly with CPSC. And we're focusing on the Clementine Bistro set. So here are our facts. Furniture Co. is an importer and retailer of outdoor furnishings. They sell online and in brick and mortar stores. And they recently hired a product safety manager who registers on CPSC's business portal. And she notices that there's a Safer Products report of harm that was made in November 2020. The product identified is the Clementine Bistro table. The allegation is that there was a sharp edge on the underside of the table and the consumer cut her finger. She was able to self-treat it, and she bought this table in the summer of 2020. So the product safety manager is a bit intrigued. She knows the Clementine table bistro set is still for sale. It's an active SKU. And so she starts to look into this a little further. Based on facts, she knows that it was introduced for sale in May 2020. It was produced by an overseas supplier, and they've sold 10,000 units. So the product safety manager decides to look into available sources of data to see if there's been any other complaints similar to what she saw in Safer Products. She requests that customer service send up any complaints on the Clementine Bistro set, and she receives a spreadsheet that summarizes 4 reports of minor cuts to fingers from the metal edge under the table. Now, all the consumers purchased their product, they said, between June 2020 and November 2020, and there have been no complaints filed after December 2020. She also doesn't see that any claims were filed. She checks with the quality department, and there's some anecdotal evidence that there was a product change made to address a quality concern about rough metal edges in September 2020. Unfortunately, there's no tests or an inspection reports or design drawings maintained by Furniture Co. And so information has been requested by the supplier. So at this point, she thinks there's probably a small population of affected units, if any. There was a change made in September 2020, and there's now what she knows 5 reports of what appear to be minor injuries from cuts under the table. And these all seem to have happened prior to the change that the supplier made. So she reports it to her senior management, and they're aware that there have been civil penalties recently for several $1 million for late reporting. The company considers it, and in an abundance of caution, they look at their options. Do they not notify and just gather additional information? Do they notify but say no recall is warranted? We're just doing this in an abundance of caution. Or do they notify and say, do they notify and do a fast track recall? So the company thinks about this and decides they're going to report, but say that no recall is warranted. So just stopping here, let's think about some of the keys that Eric mentioned earlier: credibility through preparation. Does Furniture Co. have systems to collect and monitor and evaluate safety information? We know some information was collected. We don't know at this point that it's been all the inputs of information have been at least tapped, and information, there's been an attempt to identify where that information might be and collect it. Does Furniture Co. know the facts on all incident sources? No, not at this point. So I think the preparation is a little bit in question. Credibility through communication. What Furniture Co. will need to do based on the information they've collected is ensure that they're accurate in their communications to CPSC. Again, their facts aren't aspirational. They may make, you don't want to make assumptions in your report to CPSC, and it's very important to distinguish between what are working theories and what are actually facts.
Yeah, and just to pause here, the point here is not that Furniture Co. absolutely must notify CPSC based on 5 reports of minor cuts that they've identified. That's not what we're getting at here. They do have the 3 options that Michelle outlined, and they have picked one of those options. So having chosen to stop the clock on any reporting obligation by notifying, what Michelle's addressing here is, okay, you've made that decision. What do you need to do now to effectively communicate to CPSC in your reporting?
And just to touch it, and we're also by talking about credibility through preparation and have they really done what they need to do to prepare, we're not suggesting that you need to wait and make sure that you've gathered all the information from every single source and nailed down, closed every door. But you need to know where the information is and what you do and don't have, so that you can describe that accurately in your report to CPSC.
Right, and then supplement it in your full report, right? So you're going to act on the information you've identified. If that's enough to trigger in your mind it's the right time to notify CPSC, by all means, go ahead and do that, and just be clear on what you've identified so far and that your review is continuing and that you'll supplement.
So with that background, Furniture Co. makes an initial report, and Eric's going to talk about the initial report.
Okay, so in sum, what Furniture Co. includes, it's an initial report. In addition to identifying itself and who's making the report and what the product is, it says we've received 5 minor cuts, no stitches. It tells CPSC that in September 2020, there was a manufacturing change to address a rough edge under the Clementine table. It says that only 2,000 units were produced before the manufacturing change was made. And it says definitively that everything manufactured after everything sold after November 2020 has the manufacturing enhancement. And so all of those units sold after November 2020 are not affected. It also says quite definitively that given the small number of units, the low number of minor incidents, the small, specifically 5 reports without any stitches, and the fact that there have been no incidents received in over a year, there is no defect, there is no substantial product hazard, there is no need for a recall. So now There's going to be a CPSC full report request, like night follows day. You could count on this virtually anytime you make an initial report to CPSC. There can be some relatively rare exceptions, but you should count on this coming. And here, that's exactly what happens. Some notable items that they're going to have to be including in the full report are copies of the complaints and claims, regardless of whether there was injury, test reports, analyses, and evaluations, identifying any product changes, identifying the distribution of the product and the scope, those that are inside the scope of what's being reported, and a whole host of other information. But this is these are among the key points.
Eric, if I could ask you to pause for just 1 second. We have a great question from the audience here that's asking, without test reports to support that the change in the process has been verified, is that something that you would consider a fact when the company is sharing that information?
It's a great point. Here, just to use this example, if we know that there was a product change and we know from the manufacturer what that change was, so even without a test report, we know that there was a rounded edge. I'm making this up now, but let's assume you know this. The manufacturer has represented to you and provided support for the fact that a rounded edge component was substituted for the flat edge that had been previously provided. You can certainly say that, and you can say that based on the information that we've been provided, we believe that this addresses any sharp edge issue. And that is sticking with the fact. Would you need a test report that used CPSC's sharp edge protocol to establish that the edge was in fact not sharp? I think that really depends on what, the extent to which you are comfortable with the information that you've received from the manufacturer, and perhaps just even going to samples in inventory and saying, oh yes, I can see that on the new units, it's now a rounded edge, it is not sharp anymore. That might suffice. In other cases, it would really be important to have test reports. If we were talking instead about whether a product was a children's product for young kids, and the issue was, did it have a small part in use and abuse testing, I would sure want new test reports to show that the change did in fact preclude there from being a small part in use and abuse testing, rather than just saying that. Does that do it?
I think so. Very helpful. We have a little.
Yeah, Don Mays points out there should have been an engineering change notice to indicate when the design change was made. That is surely true. That is something that CPSC is going to want a copy of. It's going to be something that you will want a copy of just to satisfy yourself. And again, is that the be all and end all? Not necessarily. You can have an engineering change notice and the change may not have been effective or may not have actually been implemented. But yes, every bit of evidence here that you can collect to show that the change was made would be useful and important. So after submitting the initial report, additional information is identified. This is not uncommon at all in our experience. In fact, it may be more of the rule than the exception, that what you knew at the time of the initial report is only a piece of it and not all of the information that subsequently becomes available. So what do they learn? They have now received emails and call comments for the 4 reports that were in their spreadsheet. This additional information indicates that 2 of the cuts, in fact, involved stitches where they had previously believed based on their spreadsheet that there were no stitches, and they had told CPSC that there were no reports of stitches. While those reports should have been escalated under the company's SOPs, they weren't. For whatever reason, it didn't happen. They've now also looked at a returns database, which in this company is a separate database in its own silo, not connected to the customer service database. And they've identified, excuse me, 100 returns of the bistro set, and 16 of those returns include comments of lacerations or cuts to fingers or hands. And 10 of those reports are actually for bistro sets purchased in 2021, where they have previously believed and previously told CPSC in their initial report that this was all ended in 2020 and wouldn't affect any sales thereafter. They've also now had a chance to look at the online reviews to the company's website, and they have found 3 reports of concerns about sharp edges on the table, and the company does not have a process in place to routinely review those online reviews.
Eric, if I could just stop right there.
Sure.
I mean, this is not a fanciful scenario, and I can't tell you how many times we work with companies that will provide summaries of incident reports, and we're always asking for the source information, because sure enough, you can find that they're not always summarized accurately. They don't describe the severity of the incident or other salient facts. And having additional databases that are, learned about after the fact is not uncommon. It happens more often than not.
Yeah, and again, this is an iterative process, right? The information is coming, you don't have it all at once. You're trying to meet this requirement to report immediately. And so we fully expect that the facts are going to be evolving, and we will continue to press our clients to search, and get us anything that they find, including the supporting documents, just as Michelle points out.
And I'm sorry, just one other thing, the significance of the saying that these 2 cuts required stitches is because in CPSC's regulations, needing stitches actually constitutes a serious injury. So while, it certainly is more elevated that it needs stitches, the fact that they categorize these as minor cuts and now there are stitches involved is a real change from minor to now serious injury.
Okay, so this is not the end of what they learned following the initial report. They do confirm that there was a manufacturing change in September 2020. They learned, though, that the supplier did not use first in, first out. So the sharp edge under the table could, in fact, be contained in units shipped after September 2020. And unhelpfully, there is no manufacturing date code on the product. So it's not even like they're going to be able to distinguish units made before and after the manufacturing change based on anything on the product other than actually seeing if there's a sharp edge on it. The supplier, in a fit of transparency, confirms that it actually made a similar change in 2020 to a metal edge on an outdoor dinner table in the Melanie collection, not the Clementine collection that the company has notified CPSC about. And when Furniture goes back and looks, it finds that it has 6 laceration reports on the Melanie collection table in 2018 and 2019. So we've identified several inaccuracies or lack of complete information in the initial report, right? The initial report says no stitches, there were stitches. The initial report says there are only 5 total incidents, 1 safer products and 4 in the company's hands, but there's at least 16 more incidents that have been discovered. The incidents didn't in fact stop in 2020, like they said. It's continued into 2021. The sales didn't stop in 2020, and the scope is not limited to the Clementine table. Is there an argument that they still don't need to do a recall? That's a separate issue, right? That's not what we're talking about right now. The company either, may or may not be satisfied that this product is safe to remain in the hands of consumers. It's not that the company is obligated to go to CPSC now and say, we're doing a recall. However, the company is obligated, and it's key for credibility and to protect the company from additional liability, that the company be forthcoming with CPSC and acknowledge additional facts. I see a question here, how the online negative review will be considered in a regulatory environment. Is it a customer complaint? A great question. In our experience, CPSC will treat an online complaint like it will other complaints. It may or may not be credible, just like a consumer complaint directly to the company in the company's database may or not be credible. It may or may not be confirmed. It may, in fact, overlap with one of the complaints in the customer service database, and you may not be able to sort out whether it's duplicative. But CPSC will take it as a data point, and in our experience, will expect the company to at least be familiar with the online complaints to the company's own website. Again, putting aside credibility, whether it's confirmed or how much weight it should be given, that's a different issue. So, applying the keys to successful communication with CPSC, what's the next right thing to do is kind of a shorthand way to think about what you're going to be doing next. Certainly, submitting an accurate full report to CPSC reflecting the additional information that has been now identified. Would really want to double check the accuracy of the incident information and the other data. Something that should have been done already, but if not, should absolutely be done now, is to consider whether any other data sources that may have been missed the first time around, so that at least when you go in with your full report, you are now able to be convinced that you've hit upon each of the potential inputs to the company. If the company is still not convinced that a recall is warranted, it would be appropriate to consider engaging a third-party expert or doing your own testing to evaluate the severity of this risk and how broad it might be. Acting on the changed facts, revisiting the decision about whether a recall is warranted, even though the company thought it wasn't warranted initially, now would be a good time to reevaluate that. Supplement your submission to CPSC. And again, if there's going to be ongoing testing or analysis, you'll be considering whether to update CPSC once that additional testing and analysis is done. So, how do you overcome the challenges that we've identified in meeting your reporting requirements to CPSC, given the time pressures and other complications. One, you need a compliance process. Second, you're going to absolutely want to know that you are familiar with all the applicable requirements, not only mandatory standards, but industry consensus standards and your own specifications, which hopefully the folks involved will be aware of, but you should not assume that they do know what they are. Within the company, you should identify who owns the issue at each stage of the product's life cycle. Issues can arise if a product marketed for one use, suppose the product's marketed only for commercial use, is subsequently marketed for consumer use. It's not good enough to say that the team owns an issue. Someone should be on point. If only a group owns an issue, it could be more likely to be missed. With your supplier, in this case, were there change controls in place so that you are put on notice when, for example, the manufacturer made the change to the outdoor dining table as well as the home use product, in-home use product, and tracking regulatory development is also very important. Michelle?
Sure. So, so just talking about identifying inputs, you know, the diagram here is not to show you exactly, you know, what you must do. Each company is different. You all might have some different inputs, and there's not a cookbook approach. But what's important is to know the inputs for safety data into your company, and that may be warranty, a warranty database, marketing website comments. You may have, you know, a risk department, so you can look for legal claims, customer service reports, whether that's, you know, emails, summary notes from customer service. It can vary from company to company, but the key is to know exactly where those inputs are, have somebody monitoring them so that when an issue arises, you know exactly where you need to go to get the information. And if the information is not available yet, you know, to let CPSC, if you're reporting, know that that's coming, and you can write around that issue, the unknowns, more effectively. The other thing to talk about,
Michelle, before you go on, this slide is one of the first things we talk to clients about on two different issues. One, if a company says, help us evaluate whether our process for compliance with Section 15 is adequate, this is where we start, right? Because if you don't know all the inputs to your company, you're going to have a heck of a time trying to comply with the Section 15 reporting requirements because you don't even know what you have. Likewise, if you're deciding whether in a particular case you've got a duty to notify CPSC or whether you should consider doing a recall, if you don't know what all the inputs are to your company, you're only looking at a piece of the puzzle and may not be making an informed decision.
So Eric touched on before who owns the issue. And again, there needs to be an identified person that is going to be monitoring each various buckets of information and escalating potential issues for further evaluation. You need specific individuals or teams to decide whether to notify CPSC and to determine next steps to address an issue. And again, with this, there's no one size fits all approach. Some people might have a product safety team, a product safety manager, but you need point people to be responsible and own each issue at each step of the process. And then we just want to touch on training and communicating with employees about safety and encouraging employees to report potential issues. You know, there should be a system for onboarding training for employees and periodic training thereafter, whether that's, video or in person, however that's done. And the reason for that is, everybody's got their primary job description. And usually when we give this example, we pick on customer service, and I'll start with them and expand it. For example, customer service, one of the primary responsibilities is, to ensure customer satisfaction. So they may receive a report from a customer that's describing an incident, and the customer service person rightfully tries to address the issue, satisfy the customer, but that's not the only obligation, right? If there's actually a safety issue or a potential safety issue that's been raised, their responsibility goes beyond satisfying the individual customer, and then also looking how they're supposed to escalate the issue internally. Similarly, I'd say, that can apply to, you may have a whole social media marketing team, right? That's managing, the social media and how the product's being promoted. They may also be monitoring reviews. There should be an SOP in place or training so that they understand when there's a potential safety issue raised in an online review, that gets escalated to the appropriate team. So that information isn't siloed. And similarly, I can't tell you how often, you see through email strings that there's been a change made to a product, the suppliers made a change to address an issue, and that hasn't been communicated to the product safety team, right? The supplier is making a change to address, they know that there's been some customer complaints about a certain issue, and it's looked at as a quality issue. Not saying that that's a bad thing, that there shouldn't be a change, that products shouldn't be improved upon, but to understand that that product change can be looked at by CPSC as a flag for when the company knew about a safety issue. You need to make sure that your internal teams, like the quality team, understands that that type of information could be a safety issue trigger, and it gets escalated and communicated to the right person or team of people that manage that.
On this training point, we're not suggesting in any way that there is a one-size-fits-all approach to training. We're not suggesting that there's a one-size-fits-all approach to how to make sure that the potential safety information gets in the hands of the people that need to evaluate it. But somehow, some way, the people with responsibilities have to know what their responsibilities are, and somehow, some way, the information with potential safety consequences needs to get up to the people that are in a position to evaluate it, monitor it, and act on it. So let's think about overcoming challenges once a potential safety issue is identified. What are you going to want to use as a part of your checklist of things that you're going to need to do? First, time is of the essence. You're going to want to learn the facts as soon as possible. This is not a time for it can wait. I've got a long list of priorities, and this potential safety issue is just going to have to wait along with all the other things I've got on my plate. When you are considering an issue, distinguish between a failure to comply or potential failure to comply with an applicable mandatory standard versus other undertakings. For example, an industry standard or an internal specification. Any of the three can have potential consequences. Can have potential consequences for reporting, as you probably know. If you violate a mandatory standard enforced by CPSC, automatically you need to notify CPSC about that. You might also have a duty to notify CPSC if you don't comply with an industry standard, or if you don't comply even with your own standard, because the standard for reporting to CPSC is, does the information reasonably support the conclusion that you've got a safety defect, is a shorthand way to say it. And the failure to comply, even with an industry standard or your own specification, may support that conclusion. but you really do want to distinguish between or among these three. Of course, you're going to notify the regulator, excuse me, if appropriate. You're absolutely going to want to scope out the issue. We think about this as drawing a fence around the problem. Of course, it is appropriate to draw a fence. You don't want to recall products or notify about products that are unaffected. At the same time, the consequence of drawing the fence too narrowly is that you may be supplying inaccurate information to CPSC or incomplete information to CPSC, which is never a good thing. And you may find yourself in a position with a very unhappy position of having to expand the scope of a recall once it is announced. We have been there with clients. It is one of the more unhappy occasions where a company, having gone through the burden of conducting a recall, finds that it now has to go out and announce the recall a second time. You really want to get this right, if at all possible, the first time around. And it is, we talked about this before, but you're going to have to be willing to revisit decisions and the assumptions underlying those decisions as warranted. It is not going to work to say we've already evaluated that issue. We've already decided the product was safe. We don't need to think about it anymore. As the facts change, you absolutely do need to think about it some more. And then finally, you're going to want to have the discipline to document a potential safety issue from start to finish. We've done workshops on this one slide alone. What do we mean by this? It can be very tempting to be satisfied with saying, we've now determined that that potential safety issue that we had many emails about is not a potential safety issue at all, and be done with it. My job here is done. I can go on to the next issue of the day without documenting it. The problem with failing to document it is that years down the road, in a product liability context or a CPSC late reporting investigation, all you're going to have are the quote unquote bad documents, the documents indicating that there was a potential safety concern. And if no one has the discipline to document why it turned out that there was not, in fact, a safety concern, you're going to have a heck of a time piecing that together down the road or convincing anyone that that's what you had in mind. It's critically important that you write clearly and convey context. If you're referring to test reports or evaluations or analyses that have been conducted, we would attach them to the email or memo that is going to document the issue. You should assume that emails and other documents may become public down the road. You're not just writing for now, but you are writing for the future. You should not overstate the case internally to business partners, consumers, or CPSC. It can be very tempting when communicating with a supplier whose attention you are trying to get and who may not understand the gravity of the situation to overstate the situation. If you have not concluded that there is in fact a safety concern, then you might think twice about going to the vendor and saying this is a deadly dangerous safety concern, just because you think that's what you need to say to get the vendor's attention. That would not be a good practice. Stick with the facts. Close the loop. If it starts in writing, end it in writing. Explain why it is that you've determined, if it's the case, that what was a potential safety concern is in fact not, or how you determined that the scope was as you now believe it. Finally, just a very brief note, you should understand privilege, particularly when dealing with in-house lawyers who wear multiple hats. not every communication with an in-house attorney is going to be privileged. You should feel comfortable talking to your counsel and understanding, have a meeting of the minds as to whether your discussion is going to be privileged. Under the law, the attorney-client privilege protects confidential communications between an attorney and a client for the purpose of providing legal advice. There's also protection under the work product doctrine for work done at the direction of an attorney in anticipation of litigation. As a non-lawyer, it's not expected that you be the master of these concepts, but you should know enough to ask about them and to have an understanding about the scope of the protection. The facts are not privileged. The fact that you got a complaint, the fact that you had a test done is not covered by the attorney-client privilege, but your communication about the legal consequences of those facts can be privileged. And you could do testing under the attorney work product doctrine, which may or may not be protected from disclosure. Let's see, there's a question in the box. When the products are sold by supplier or distributor and the consumer had issue with it, this situation, who is responsible, the supplier or distributor, the manufacturer? The answer is yes. The answer is all three, as between the companies and CPSC, anyone in the chain of distribution can be covered by the duty to report to CPSC. CPSC will typically look to the entity furthest up in the supply chain in the United States to address an issue. However, a mere retailer purchasing a product from a domestic manufacturer, that mere retailer, if the retailer has the information, they can be on the hook for reporting to CPSC, and CPSC can and has sought late reporting penalties against multiple parties for the same issue. Let's see, there was a question here. I have an issue with my product, which is UL certified and is having an issue which may require a recall. Whom should I inform first, UL or CPSC? A great question. You can have a contractual obligation to UL, assuming they have certified or listed the product. I would say, Michelle, do you agree with this? Contemporaneous. There may be reasons why it's important to go to UL first or CPSC first, but we would not want there to be a significant gap between notifying either. Does
that sounds right. I think the goal is contemporaneous or in close succession.
We still have a couple of minutes. Any other questions?
Yes, we do have a couple of questions that came in through the Q&A. Maybe we can do these rapid fire with our 2 minutes left. So the first is whether you could recommend any available templates that could be used to document decisions and contextual information.
I don't think we have a template to do it, but there are key points that you're going to want to cover. I think to address this one, be happy to talk to you offline. You can email us. We'll be happy to talk to you about it. But you think about testing, scope, incidents, evaluation, analysis. Michelle, there may be other points that we'd want to cover, but these basic points that you want to cover in any such assessment.
Yeah, and I guess just also, the information may, the bad information may have come in through, in email, and so I think just that the matter is if you've got information afterwards that dispels the fact that there's a safety hazard, to save it in close proximity, whether it's as basic as you have a folder on this product and you're going to put it there, but so it's accessible. It's not just in your email from 2019, not attached to the test report on the H drive.
Good point.
One last quick question. If the CPSC sends a notice of violation to a company, is the company then still required to submit a 15B report?
Maybe, maybe not. The only exception for the duty to notify CPSC is if you have actual knowledge that CPSC is adequately informed. CPSC would interpret that to mean that CPSC has all of the information that would be included in a full report. I would probably say it a little bit differently, but certainly all of the information that be relevant to evaluating the issue. So typically when CPSC sends you a notice of violation, they're going to be asking some questions in that letter. You should definitely use that as an opportunity, getting that notice of violation, to consider what additional information you have, incident information or other information that would be relevant. So you might need to submit a full report. You could also communicate with whoever you got the notice of non-compliance from and see if there are any questions that they still have about the product.
Excellent. Thank you. We are at our time, so I'd like to wrap us up. Eric, Michelle, thank you so very much for your time and willingness to share your expertise with us today. For our audience, we do have email addresses for Michelle and Eric on screen. I know they welcome any questions you might have that you'd like to discuss offline, so feel free to reach out if that is the case. I thank you all for joining us today. We have 3 webinars left in our 7-part series on communications. They will all take place next week on Tuesday throughout the day. And we'll be talking about crisis communications, communicating with media, and looking at global trends and sustainability and how we can really put our communications hats on around educating our organizations within the product safety realm about those very important things that are taking place. So once again, thank you all for joining us. We look forward to seeing you all again next week on Tuesday. And I hope everyone has a wonderful rest of the day. Michelle, Eric, thank you again.
Thank you so much.
Thank you guys. Really appreciate the opportunity.